Thank you and good morning, Mayor and Commissioners. Today I'll be presenting a work session on our Wetland Conservation Areas Ordinance. This will be an overview. Here is today's agenda. We'll cover our purpose of the work session, a section on the importance of wetlands, wetland definitions and protections, our development review process, specifically to wetland impact permit reviews, section on prior board direction and feedback for impact approvals, property rights and takings, an ordinance update work plan, and a summary. So staff, as you're aware, is currently reviewing standards and processes to update Chapter 15, Article 10, our Wetland Conservation Areas Ordinance. We have a number of ordinances actually at EPD that we're reviewing, but we're just beginning to get to Article 10, which was recently invigorated by Mayor Deming's Customer First initiative. So there's several issues that have been identified from numerous groups about our Article 10. Those come from staff with issues related to implementation and effectiveness of the code. Also, citizens raise concerns through the district commissioner offices about review processes and how different projects get approved. The development community has had concerns about consistency and predictability of the process. And lastly, the commissioners raised concerns during various development-related public hearings about the process, the code, and what gets approved and what doesn't. So today, I'd like to provide an overview of our wetland permitting legal framework in Florida and our own development review process. And then lastly, I'll share an ordinance update work plan that we have, including our process and schedule. So wetlands are important, obviously. They provide a range of ecosystem services that are important to our way of life. I'll cover some of the most important ones. They provide aquifer recharge. 92% of Florida's population depends on groundwater for drinking water supply. And wetlands help purify and replenish aquifers by removing contaminants from runoff and recharging our groundwater. Next, but not certainly least, is water quality. So wetlands are really important for absorbing excess nutrients from fertilizer runoff and pesticides. And one of the examples of how they do that and where it's being done is Orlando Wetlands Park, which somebody mentioned in public comment today. That was a artificially constructed wetland, and just last year it processed approximately 21 million gallons of reclaimed water per day, and it removed 56.8% of total nitrogen and 67.1% of total phosphorus before discharging to the St. Johns River. And that Orlando Wetlands Park is located in East Orange County near Fort Christmas Park. Wetlands are also important for biodiversity. So most of Orange County, just for example, is within a core foraging area for wood stork colonies. Additionally, 369 different bird species have been recorded on the Lake Apopka North Shore, or LANDS, Wetlands Restoration Project. In fact, the record for the Christmas Day bird count event in Florida, which has been held since the 1970s, that count stands at 174 species at LANDS. And then lastly, wetlands are important for environmental resiliency. They're important for carbon sequestration. Peat wetlands cover 3% of the earth, but they actually hold 30% of all the carbon stored on land, which is twice the carbon stored in our forests. And wetlands are important for flood attenuation. A 2017 study after Hurricane Sandy, which occurred in 2012, indicates wetlands prevented an additional $625 million in flood damages in New Jersey. But worldwide, wetlands are in trouble. 64% of the world's wetlands have disappeared since 1900. University of Florida IFAS indicates that 46%, or 9.3 million acres of wetlands in Florida, have been converted to uplands. And the World Wildlife Fund estimates freshwater species populations worldwide declined by 84% between 1970 and 2016. So now I'll move into wetland definition and protection section. But first, just briefly, we'll touch on what are wetlands and surface waters. We'll broadly define their undeveloped areas that are flooded with water seasonally or permanently. But we do have a legal definition in Florida that's in state statute in Chapter 62, 340. Wetlands can be natural or man-made. As I mentioned, Orlando Wetlands Park being one example of a very large man-made wetland. And of course, there's different ecosystem types within wetlands, from freshwater marshes, cypress strands and domes, and wet prairies, just to name a few of the types we have here in Orange County. And then our surface waters, of course, can include lakes, ponds, creeks, rivers, springs, and spring runs. This is a very broad-based map of surface waters and wetlands within Orange County. This is based on remote sensing data available from Florida Natural Areas Inventory. The limits of these systems haven't been ground truthed in any way, but it gives us a general idea of what we have. So surface waters account for almost 72,000 acres within Orange County, which is about 11% of the total area of the county. And then wetlands represent a little over 160,000 acres, or approximately 25% of the county's area. Next, I'll step through the regulatory framework. Of course, we have federal, state, and our own local oversight. The three main federal agencies that have jurisdiction over Orange County are the Environmental Protection Agency, the U.S. Army Corps of Engineers, and the U.S. Fish and Wildlife Service. The middle one there, the Army Corps of Engineers, does most of the federal wetland permitting, although recently they have delegated some of their Section 404 permitting to the state of Florida. And then the U.S. Fish and Wildlife Service, of course, asserts jurisdiction over endangered species, including those that call wetlands their home. Next, at the state level, we have the Florida Department of Environmental Protection. They typically issue wetland permits for single-family, standalone single-family home sites. The Florida Fish and Wildlife Conservation Commission, of course, they issue wildlife permits for those species listed at the state level. And then we have two water management districts here in Orange County. The St. Johns River Water Management District covers more or less the northern portion of the county, and South Florida covers the southern part. So now we're at the local authority level, starting with the county charter. Of course, we're a charter county, and Section 704 of the charter provides for environmental protections. The county sets standards for protecting the environment by prohibiting and regulating air and water pollution. And of course, municipalities could establish their own regulations if they are more restrictive than county standards. Next, below the charter and the organizational chart is our comprehensive plan. So within the comp plan, there's policy language on environmental protections in various elements, and those include the future land use, conservation, and open space. And the comp plan defines special protections for the Wekiva River, Econ-Lakachi River, and Innovation Way. And then finally, at the lowest level of organization, we have our code or ordinance. Orange County's conservation area protection ordinances are primarily found in Chapter 15, Environmental Control. The main article that we utilize for administrating our wetland permitting review is Article 10, Conservation Ordinance. It was last updated in 2008, although that was really just to include some new state language about the definition of wetlands. It hasn't been overhauled or looked at to improve since its codification in 1987. Then we have three special protection areas. Article 11 is for the Econ River. That was codified in 91. And then Article 13 is our Wekiva River Protection Ordinance. That was codified the same year. Both of those remain unchanged. And then lastly, we have Article 18, our Environmental Land Stewardship Program Ordinance, which we refer to as ELSP. That was codified in 2010 and remains unchanged. So now I'll step through each of those four in a little bit more detail. First, with Article 10, it establishes procedures countywide for the identification of all potential conservation areas. And when I use that term conservation areas, I'm including wetlands and surface waters. And helps identify them as Class 1, 2, or 3, which I'll talk more about later on. Article 10 helps to quantify the significance, functionality, and viability of conservation areas under natural, altered, and developed conditions. And then lastly, it helps us evaluate mitigation and compensation programs that are designed to enhance, replace, or alter functionality of conservation areas in conjunction with development activities. The requirements for impacts, which we'll discuss in more detail later, are avoidance and minimization, reasonable use or overriding public benefit, and mitigation. Next is Article 11, the Econ River Protection Ordinance. So the intent and purpose of this ordinance was to protect the public interest by balancing development, private property rights, and environmental protection. You can see the inset map on the lower right there outlines the protection area, which is 88,257 acres in size. And some of the special requirements for development in this area include rare upland habitat preservation, riparian and additional upland buffers, imperiled species surveys, native plant landscaping, and additional stormwater treatment. Next, we'll talk about Article 13, the Wekiva River Ordinance. Its intent and purpose was to protect and enhance the river's natural value for present and future generations. The protection area is almost 20,000 acres in size. You can see it on the map there in the northern part of the county. And special requirements for development in the Wekiva include riparian buffers, imperiled species surveys, native plant landscaping, septic tanks are specifically discouraged in the floodplain, and additional stormwater treatment is required. And then lastly, Article 18, our ELSP Ordinance. Its purpose is to protect wetland and uplands of environmental significance within the Innovation Way overlay. The overlay is a little over 32,000 acres in size. You can see it's identified with those light green and yellow polygons that are to the southwest of the Econ Protection Area. It actually overlaps a little bit with the Econ Protection Area. Some of the special requirements to develop there include additional buffering along the Econ River. They have to create, enhance, and preserve wildlife corridors, provide adequate crossings for wildlife and water conveyance, protect habitat on ecologically important lands, and protect rare habitat. So moving into our development review process, looking at Article 10 a little more closely, we have two main processes in Article 10. Those are the Conservation Area Determination, or CAD, and the Conservation Area Impact Permit, or CAI. Within the CAD, the review standards include connectivity, size, and classification. I'll talk more about that process in just a minute. And for the Conservation Area Impact Permit, those review standards include avoidance and minimization for Class 1, 2, and 3 wetlands, and reasonable use or overriding public benefit for Class 1 wetlands, and mitigation is always required. So looking at the CAD a little bit closer, I'm going to step through our classification system and the definitions of each of the three types. So a Class 1 wetland has a hydrologic connection to natural surface water bodies, or it is a lake littoral zone, or a large isolated uninterrupted wetland, 40 acres or larger, or a wetland that provides critical habitat for federal and state-listed threatened or endangered species. And that critical habitat term is one of the problems with our code. It's not defined. If it said just provides habitat, it might be a little bit more intuitive, but as such, critical habitat is not defined. And you may remember a project maybe 6 or 8 weeks ago that I brought before you. It was the Clap-Sims Duda OUC substation project. That small farm pond would have been a Class 3, but because there were sandhill cranes nesting in it, it was bumped up to a Class 1 per that last bullet, habitat for listed species. Next, I'll step through Class 2 wetlands. So these are isolated systems. They're isolated or formerly isolated, which by way of man's activity has been directly connected to other surface water drainage and are greater than or equal to 5 acres. So these are the wetlands that are between 5 and 40 acres generally. And then they do not otherwise qualify as a Class 1 conservation area. And then lastly, we have our Class 3 wetlands. These are the isolated wetlands less than 5 acres in size and do not otherwise qualify as a Class 1 or 2 conservation area. one of the problems with the current code is generally people interpret Class 1 to mean the most high-functioning, most valuable systems, which is true sometimes, and Class 3 generally are not that high, not that functional, and therefore don't warrant much scrutiny. But in fact, there can be, for example, this is a cypress dome. It is isolated. Just for example, it could be 4.9 acres, and if it didn't have any endangered species in it, it would fall in the Class 3, but they actually can be high functioning and very important, particularly to migratory birds as resting areas. Next, we'll talk a little bit more about the other major process in Article 10, the CAI permit. So a valid CAD is always required. We have technical review standards including avoidance, minimization, reasonable use or public benefit for Class 1s, and mitigation. We actually developed a handbook a couple years ago that I've got a little screenshot of there for you to help applicants navigate our process. So the CAI permit code criteria, you may recognize these because we step through them typically at all CAI permit public hearings. So for all wetlands and surface waters, to summarize that paragraph, essentially an applicant has to demonstrate they've minimized or eliminated impacts to wetlands first and foremost with their design of their project. Next, for Class 1 impacts, they have to demonstrate there's no other feasible or practical alternatives that will permit a reasonable use of the land, or they have to demonstrate there's an overriding public benefit. For Class 2s, habitat compensation for Class 2 conservation areas should be presumed to be allowed unless contrary to the public interest. And lastly, for Class 3s, habitat compensation shall be allowed for Class 3 in all cases. So this is a chart of our CAI permits, just the wetland impact permits that have been issued for the last 9 years. The number hovering over each of the years is the total number of permit that year. So in 2021, we had 77 at the time that this data was put together just a couple weeks ago. The area in blue on each bar is the staff issued number of CAI permits, and then the area in green is the number that went to the board as a public hearing. And you can see there's a general trend. They're usually always increasing the number of permits each year. And I'll talk a little bit more in a few more slides about which permits go before the board and which are staff issued. So here's the county's generalized development review process. Starts with future land use review, then rezoning, preliminary subdivision plan or development plan, construction plan, site plans, platting, and vertical permitting. So generally speaking, the CAD and the CAI are required prior to or concurrent with the PSP or development plan. However, if an applicant is requesting to increase density and needs wetland impacts to do that and to accomplish their development program, the CAD and CAI are required much sooner per comp plan policy. Next, I'm going to step through our typical review process for avoidance and minimization. This example will be a single family lot. So I have a commercial example coming up as well. The site plans that are submitted to us are typically reviewed to confirm that the impacts have been avoided to the extent practicable. But they can't always do that, so in those cases, we require that they demonstrate minimization. And so here is an original plan that typically comes in for a single-family home. The impacts may not be entirely avoidable, but you can see there's some upland towards the street that they could utilize. But they often want the house located as far back from the street as they can, and they usually want the house located in the center of the lot. But we meet with them. We will typically send a request for additional information or two suggesting that this plan is not entirely demonstrative of avoiding or minimize impacts. And so ultimately, what staff typically agree to is a plan like the one on the right. You can see they've shortened the driveway, they've moved the house out of the center of the lot and out of the wetland. And typically this is a site plan that staff can review, and the overall process depicts what our usual conversations are with applicants. Next is a commercial example. So this is a big box store you can see in the upper right. They also have an out parcel on the bottom right. A lot of parking there in the central portion of the site. A stormwater pond in the upper left. And a constraint to development of this site obviously is the wetland located on the left side. So typically we would ask them if they can reduce parking. Is there a stormwater pond, the smallest size it could be, because that area might be someplace that they could locate some parking spaces. Oftentimes they'll do a parking study which will reveal that they could have fewer parking spaces. Sometimes they need a variance to do so, and oftentimes those are granted in order to avoid wetland impacts. And so in this scenario, after meeting with staff, they're able to reduce the parking spaces to the extent that they can also add an upland buffer along the wetland. And in summary, they eliminated several parking spaces to remove that direct impact and add a buffer to protect against adverse secondary impacts. So next we'll step through mitigation, which I mentioned is always required for impacts. In Florida, statute requires that we utilize the Uniform Mitigation Assessment Method, or UMAM. That's in Chapter 62.345 of the Florida Administrative Code. UMAM provides a system to quantify and determine the functional value of conservation areas being impacted and or the mitigation areas being provided. And at its core, the system is the system has a principle of no net loss of wetland function at a basin-wide level, which I'll walk through that concept a little later on when we talk about mitigation banks. Some of their options applicants have for mitigation include preservation, and that can be wetland or upland, and it can be on-site or off-site. They can also create wetlands, restore wetlands or enhance them, again on-site or off-site. And then lastly, they can choose to purchase mitigation bank credits. So just an example of each of those types of mitigation. Starting with some on-site preservation. This was a real project that went before the board called Moss Park North. You can see they had 1.37 acres of direct Class 1 impacts depicted in red, as well as 0.16 acre of direct Class 3 impacts. The UMAM system doesn't award a lot of functional gain for preservation, so typically, this is a typical example where they have a lot of preservation shown in green here. 34.3 acres relative to the amount of impacts at just roughly 1.5 acres of impact. Here's another example of preservation. This one is actually off-site. This was for the All Aboard Florida Train project. They elected to use mitigation at a third-party site called the Petrozac Mitigation Area. And the great thing about this one, by the way, it's located off Lake Pickett Road, just east of North Tanner Road. This was actually, once the mitigation value was utilized, the landowner donated it to Orange County, and it's currently under the stewardship of the Green Place program. And that happens from time to time, and we're really happy when it works out that way. Lastly, I'll talk a little bit about mitigation bank credits. The example that I'm using here is TM Econ Mitigation Bank. It's the only mitigation bank located physically in Orange County. There are actually two different landowners, one being Orange County in phase 4 and 5, and then phases 1 through 3 are privately owned. You can see the bank is circled in yellow and outlined in yellow as well, and it's really small there, inset within that blue area. That blue area is the service area for the bank. That is determined by the state in this case through their mitigation bank permitting process, and it's roughly based on drainage basins. And so sometimes we get asked questions about how they derive their credits that are for sale, and that's done by functional lift. And so they improve the site from its current condition in order to get their mitigation bank permit and be able to sell credits. And they do that by removing historic man-made impacts, restoring natural hydro period, and developing and implementing management plans. Next, we'll talk about prior board direction for impact approvals. So generally, we think about impacts over time and what gets approved as a development spectrum, if you will, on the left side being no impact and the complete avoidance of wetlands, and on the right side, total impact or complete wetland removal on a site. Over time, the pendulum from left to right can swing, and due to numerous factors, probably the main one of which, for our purposes, is prior board feedback and direction. So generally, in 2003, the board was not approving Class 1 wetland impacts for lots at all. Very conservative board at the time regarding wetland impacts. But that can change as the board makeup changes. And after several years, there were some impacts for single lots to Class 1 wetlands being approved. In fact, it was occurring often enough that staff led an initiative and brought before the board a request to let staff approve some Class 1 impacts that were relatively minor. And those came to be known as the streamlining approval or streamlining projects. Those types of projects included minor impacts for road access from upland to upland where there is no other alternative, so they can't go around. Stormwater outfall pipes, restoration projects, and modifications for previously issued permits that have less than half an acre of additional impact. So those are sort of middle of the road types of Class 1 impacts in the middle of the pendulum, if you will. Then in 2016, the board was more comfortable, if you will, with larger and more frequent impacts for roads, stormwater conveyance, retention, and groups of lots. So not just single lots anymore, but groups of lots. Again, these years are just approximate, plus or minus several years, just for illustrative purposes. Some of the justifications from the development community were they had expectations based on prior board approvals, financial viability of a project, property configuration, and the classification and location of wetlands on site. And then finally, where we are today is, you could say perhaps the pendulum has swung back towards the middle or towards the left. There are fewer impacts for roads, stormwater conveyance, and retention, and lots. I promised we would talk a little bit about how wetland impacts are approved, what is the pathway that they go through. There's generally 3 of those which are based on comp plan, code, or prior board policy direction or feedback. So at the staff level, staff can review and approve Class 2 impacts outside the econ protection area, Class 3 impacts, and streamlining projects, which can include obviously some Class 1 impacts. On consent agenda, we bring Class 2 impacts in the Econ River Protection Area, and that's because of some specific language in the econ code that requires board to affirm impacts to Class 1 and 2s. And then lastly, Class 1 impacts, except streamlining type projects, come before the board as a public hearing. And briefly, I'll talk about property rights and takings and walk through an example. Essentially, this slide section is about we have to consider something for properties that are wholly wetlands. The concept of takings comes from the Fifth Amendment, which prohibits the taking of private property by the government for public use without payment of just compensation. Government actions for the purpose of protecting public health and safety, including many types of actions for environmental protection, generally will not constitute takings, but the courts have ruled that government regulation or wetland regulations affecting private property may amount to a taking. And then lastly, the Burt J. Harris Jr. Private Property Rights Protection Act provides a process for landowners to seek relief when their property is unfairly affected by government action. Under the Act, a claim exists if a government entity inordinately burdens an existing use of real property or a vested right to a specific use of real property. So just talking a little more about when staff is assessing whether or not a project that someone is proposing sounds reasonable or not. These properties are typically wholly comprised of wetlands, or perhaps they have uplands in the back that they want to utilize, but they have wetlands in the front where some impact may be reasonable. Staff always encourages them, and we have the desire to utilize all available uplands first. The applicant may need to minimize their site plan. They may not get the project of their dreams, but we have to consider that a hard line can lead to a taking situation. So here's a real-life example. This came to the board on consent agenda earlier this year. It's a single-family home located at 16728 Burrell Road. This is in the eastern portion of the county, nearby to the Econ River. Here's an aerial photo of the property. You can see there's other single-family homes on either side. This is the wetland map of the property. So the wetlands are shaded in green, and the uplands are just those areas that remain unshaded. This property had 2.16 acres of Class 2 wetlands and only 0.2 acre of uplands to work with. So the original plan that the applicant submitted along with their application proposed the house to be located in the center of the property with an extended driveway leading from the street back to the home. And this plan would have produced wetland fragmentation. There would be a wetland fragment in the southern part of the property as well as the two wetland fragments either side of the driveway. And so after meeting with them and again through our RAI process, we arrived at this final plan. They located the house close to the street. This did reduce the overall wetland impact, but more importantly, it reduced that fragmentation effect and kept most of the wetland in the rear of the lot adjacent to other undeveloped properties and wetlands that continue on to the south. And lastly, I'll walk through our ordinance update work plan and where we are and where we're headed. So our goals of the ordinance update include to identify and protect wetlands and surface waters that are most important or valuable. We want to come up with a system that recognizes functionality and not just size or connectivity. We want to examine the classification system for improvement. Keep in mind we want to balance protections for wetlands with property rights, as well as identify any exemptions in state rule that might make sense for Orange County to adopt. We want to make the process and outcomes more streamlined, predictable, and consistent. And finally, make the ordinance less complicated and easier to understand. Of course, as we work through this over the course of the next 12 to 24 months, we'll be engaging with various stakeholders, including citizens. We'll be holding charrettes as we go through our update, consultants, the development community, NGOs like Florida Audubon and Sierra Club, and lastly, getting input from staff. So our process and schedule, where we are right now is we have a term contractor assisting us with two studies. One's on the regulatory framework in Florida and one on the state of the wetlands. The first one on the framework, they're going to be assisting us with a review of wetland regulations at the state and the federal level to see exactly what they're doing. And most importantly, and most applicable, I think, is they're going to be reviewing the Wetland Ordinance in local counties. You can see them listed there for comparison and contrast with Orange County's current ordinance. They're going to interview staff from those counties to evaluate their procedures, including their successes and challenges, and see what has worked well for them that we might include in our new ordinance. They'll be reviewing Orange County comp plan policies and how they can be better integrated in Article 10. They'll be interviewing up to 10 local consulting firms to get their input on strengths and weaknesses of our code and their recommendations. And then lastly, interviewing EPD staff for those same kinds of reasons. Next, the vendor is going to help us with state of the wetlands research. So this is, the point of this study is to look at how much wetland do we have today, because even though I showed you a map, that's very coarse data. They're going to have some techniques that are going to refine that map, and also look at historically, where have we come from? How much wetland did we have? How much do we have today? And then what does that trend line look like? And so in the future, is our current policy strong enough, or does it need radical improvement to ensure that, in 2030, 2050 and beyond, we're going to continue in Orange County to maintain the level of ecosystem services that wetlands provide. And then looking at our process and our schedule in particular, besides today's work session, we have 2 work sessions that we're planning next summer. In June of 22, we'll be presenting the findings on the state of wetlands research, and then in July, another work session on the regulatory framework study. And of course, in both of those, we're always looking for policy direction from the board. And then we plan to be drafting the ordinance from July through next winter in 2022. Have some stakeholder charrettes while we're doing that in the fall of next year. And then we'll be doing obviously some more draft review and discussion to follow those charrettes in January, February of 23. Then immediately following that, we'll go right into bringing the ordinance to our advisory boards, LPA, EPC, and Development Advisory Board, to get their recommendations. Then finally in March of 2023, reviewing with the mayor and commissioners another BCC work session on the final draft ordinance in April. And we're hoping in July of 2023 to have our ordinance adoption. The spectrum of proposed development impacts varies over time based on board direction and feedback. Denial of some types of wetland impact requests may constitute a taking, but it depends on the situation. And lastly, our ordinance update is underway with the goal of adoption in July of 23. That concludes my presentation, and myself and several other EPD staff are here if you have any questions.
All right, Tim, we do have some questions and comments by members of the board. We'll start with Commissioner Wilson.
I am so excited about this discussion that I like, my heart is beating and my mouth is really dry, but it's because I feel so grateful to be able to do this right now at this time before we take one more step into the future, understanding what's at risk. And I so appreciate the presentation and the deep dive into the language and in the comparison with other counties. And I think there was a couple things I wanted to make sure that we rewound a little bit on and tied in. There's been questions that I've received from residents about how does the charter amendment and the right to clean water play into this discussion and to our permitting process. And as somebody that was involved from the ground level with a group of citizens at that time, I just want to make sure that people understand permitting is by nature permission to do something. Permission to harm, permission to take, permission to do something. In all other aspects of government, when there's a permit given out, a building permit, a business license permit, the entire spectrum, usually, of judicial options are available to the parties involved. When it comes to permits in nature, as it turns out, there's a party involved that does not have the opportunity to walk into a courthouse and say, I've been wronged. And so there's a gaping hole between that permission process and the ability to protect and advocate for an entity that has no legal rights in its own. The citizens that came forward were interested in two parts of this. One of them was for Orange County residents to be able to say, hey, listen, in that process, I understand that the reason why it was approved was because under code it was considered a reasonable use of the land, and that there was no viable alternative. But I don't think that that was a reasonable use of the land. Now, that sounds like a debate that you would have in a hearing, right? Some kind of a hearing where there was a plaintiff and a defendant. But nature doesn't ever get to be that defendant until we've harmed a human. And this is why when we talk about big environmental disasters that have happened, whether it's Flint, Michigan, or Deepwater Horizon, we don't know about it until people are really damaged, because we don't get a chance to walk in the front door of a courthouse until we've damaged a human or private property rights, but we haven't gotten there yet. So I think, to start there and understanding the intent of the right to clean water and giving an option of checks and balances to the discussion, because I think that in our scope here and trying to help development move forward and trying to make sure that we're growing in the right way, we have to operate in these processes. We have to have a way to evaluate, well, what are we going to do on this piece of land? And this takes me to my sort of first observation, since I got here, and I think it was one of the first months, one of my first meetings, there was actually a wetland impact discussion where I said, and it was a class 1, and at the time I said, the reasonable use of this and the viability of an alternative were determined because of the platting, right? The zoning and platting were done. So if we could go back to the slide that shows that development process, I just want to point out where I feel like you all, as the evaluators of these permits, are really painted into a corner. And I went back and actually listened to some of my comments and some of the things where I tried to deny based on class 1 impacts. And my question had gone back again and again to who determines that there is no viable alternative? Well, ultimately, it's that balance, right? And we don't ever get to hear from the body of water. So it has to be, on one side, very, very, I believe, well-versed advocates for the applicant. And on the other side, EPD is trying to okay, let me. And so I think it puts everybody in a very difficult position, because so when we look at future land use zoning, preliminary subdivision plan, we've now split this all up. And in this particular case that I'm referencing, the sincere representative of the applicant said that, here are the residents that believe this is where that ramp and dock needs to go. And on the other side, we did have some scientific experts that said, actually, that's an estuary. It's a critical class 1. And we felt like the balance was sort of between, the advocate saying, no, this is what these citizens have relied on, and what the reasonableness factor that is in the code, this under the basis for review, class 1 conservation area, removal, alteration, encroachments shall only be allowed in cases where no other feasible or practical alternative exists that will permit reasonable use of the land. Well, the reasonableness factor and the alternate use was already decided 2 bricks before. So I think the takeaway is, if we are going to revamp this code, and I've tried to explain this in so many of our land use cases where I've said, look, if you are, now we know that it's zoned for this density and the future land use is for this use, but we have a certain amount of acreage and we know a certain amount of that acreage is undevelopable, then we've affected from the outset the reasonableness and the alternative use. Okay, so that is my sort of where I've tried to take these discussions oftentimes when we have these wetland impact votes that have come up. And I know it's, there are many factors in play. It's not just an evaluation at that point, right, of the wetland that is being contemplated, but a class 1 wetland is deserving of coming in at future land use. So that is something that I just want to make sure that, I'm putting out there, and it falls in line with the right to clean water and the idea that if there is a water body, there is an open water or a water resource there, that it should have some footing in the conversation from the get-go about what the reasonable use of that parcel is. So that is sort of my first big jump in. I also wanted to say, I think, and this is something that we've agreed on before when we talk about it, the classifications from 5 acres to 40. If we could look, dig into that, and this is why I'm very curious to see what's going on in some of the other counties. To me, that from going, that 5 to 40 is the difference between us being able to discuss this or not, and or being able to have some other conversations with an applicant. And I think, when we sit down with applicants, and they're usually very amenable when we say, hey, can we look at this in a different way? But if it never gets to us, then, and that stuff's just gone, it's gone. And I know the other slide, if it's okay, Tim, will you go back to the one that had the wetland map, the whole county that showed the little green? All right, so many times we have discussions in here, and there have been occasions where after meeting with residents who live in some of these areas where some of those, that green is there and they're concerned, and there's a discussion that needs to happen with them and the applicant, I've tried to make some legislative action up here in a development case and been shot down, and it moves on forward. And the reason I hear back is sometimes, because there aren't any wetlands out there. No, that's all upland. Well, I've got some pretty good evidence now that I get to say, no, the residents out there that are concerned about the wetlands have a very valuable reason to be concerned. And guess what? Even if you're not concerned about those residents, that water heads on down the state, folks. It heads on down the state, right through, those big, huge parking lots out there that we require, because that's another broken part of our code. So parking lot minimums are ridiculous, and they have to go. Another issue. So anyway, I just want to make sure that when we talk about how that process goes forward and the things that do get to come to us and the information we get here at that time, all we can do is make decisions based on our current code and our current evaluations. But those things do have, right now, some openings that are judgment calls, and that reasonability, that the idea that you have no other viable alternatives other than to affect that class 1, to me, is very much a judgment call. And so just to my commission here now, until we get this all updated, I just want to plead with you that when we talk about those reasonableness factors, and that we know that EPD is very much hemmed in by the code as it's currently written, that we can evaluate then how reasonable that is, that it doesn't have to necessarily be a all or nothing conversation. So that's sort of my plea here. And then I think, if I haven't gotten all of it out, mass grading. So can we get back to mass grading and mass grubbing at some point? I want to know where that takes place in the development process, because the other concern is that if that's a DRC decision that happens even before that first brick, or in between the first and the second, that I think this is all for naught, because in some of those cases, we're missing the boat. We don't even know what's there. By the time we get out there, it's scrubbed clean. And so, making sure that wherever that mass grading, mass grubbing conversation, and I know it's out there too being looked at, and I'm so grateful for that, because, we don't have, when it's gone, it's gone. When it's gone, it's gone. So, we owe it to our children. Finally, there have been times up here also where there's conversations about the other entities, right? So you presented on the state's responsibilities and Environmental Protection Division, and also the Army Corps of Engineers. And I just want to remind everybody who follows these things, even in a very casual way, that under the Army Corps of Engineers, we just about killed the Everglades. They're pretty much primarily responsible for what happened in Hurricane Katrina. So if we have a chance to be able to hold our own processes here in-house, I'm not handing power to them. And then the other one is, the state. I get it, right? They have, there's a layer there, and we work with our water management districts, and I appreciate that. But the state also permitted Piney Point, which is currently poisoned all of Tampa Bay. The state has permitted all the phosphate mining. So I want to make sure that in the few opportunities that we haven't lost our chance to govern here, home rule, that we don't give that away and say, well, they take care of that at the state and the federal level. All right, thank you so much again. I'm looking forward to this continued conversation. I really appreciate all your work.